This lecture will be another important part of environmental law and that is relating to Forest Conservation Act 1980 and the Amendment Act of 2023. So, the very introduction that relating to the Forest Conservation Act 1980. The Act's main aim and objectives are to combat the rapid decline of forest cover on the country, to check deforestation and forest land being used for non-forest purposes. The main concern for the central government to the transfer of forest land for various developmental, commercial, and industrial purposes. So also, forest land being allotted to landless and other categories of people for agricultural purposes. So, the government to make rules and regulations to stop the use of forest land for non-forest purposes. In light of the above, the Supreme Court for the apex court in T.N.Godavarman case in 1997 amplified the term forest in its dictionary meaning all forest land even its ownership recorded in the name of any private person. So, it expressed that the fact that the act must apply to all forest land. The term must understood by its dictionary meaning and includes all recorded lands falling under the Forest Act. So now you would go to the very definition as provided under section 2 and that is relating to reserve forest. So in particular in T.N. Godavarman case in 2016, 2006. So as per the provisions of section 2 of the Forest Conservation Act 1982, it deals with the respect to reserve forest or any portion of such reserve forest, use of forest and for any non-forest purpose lease of any such land to any private person, authority, corporation or agency or any other organization by the government. There is the prior approval of the central government is required and it also in particularly defined what exactly non-forest purpose includes. It is a breaking of or cleaning any forest and for the cultivation of tea, coffee, spices, rubber, palms, oil-bearing plants, horticultural crops, or medicinal plants. Non-forest purpose also was held in the second most important judgment delivered by the apex court in 2006 that is known as the second T.N. Godavarman case of 2006 in which the Supreme Court held that the Mumbai water supply project within the Sanjay Gandhi National Park illegal and violation of the provisions of the Forest Conservation Act 1980. Further, it directed the Ministry of Environment and Forest not to grant any approval under Forest Conservation Act 1980 and the Wildlife Protection of Act 1972 for thus of the forest land falling within the national parks and sanctuaries without complying the directions of the Supreme Court. Further, on the question of lease of forest land in the important leading case, that is Nature Lovers Movement case of 2009, the Supreme Court insisted on cancellation of lease and non-renewal of lease of forest land and also held that area not particularly relating to cultivation, relating to non-forest activity, and as while Section 2A of the Act provides appeal to National Green Tribunal and for the establishment of advisory committee. So it provides appeal to National Green Tribunal to any person aggrieved by an order or decision of the state government or any other authority. So also the Act provides constitution of advisory committee to advise the central government on the matters connected with the conservation of forest. And as while Section 3 of the Act provides penalties for contravention of the provisions of the Act, as it provides penalty for contravention of the provisions as provided under Section 2 with a simple imprisonment extending to a period of 15 days. And as while Section 4 of the Act provides the liability and legal proceedings, and in particularly it provides liability and legal proceedings against government heads of departments and any other authority committing any offense under the Act, unless it is proved that such offense was committed without his knowledge or that he exercised all due diligence to prevent the commission of such offense. So, almost in this regard, we have discussed all the important provisions of the Forest Conservation Act 1980, and in particularly we have also discussed the very concept of non-forest purpose, as we have already discussed for the use of plantation of tea, coffee, rubber, oil producing plants and other specific purposes. So now we would like to discuss the Forest Conservation Act 2023, the very introduction and comparison in between the Forest Conservation Amendment Act 2023 in comparison to Forest Conservation Act 1980. So the Act renames the Forest Conservation Act 1980 as the Forest Conservation and Amendment Act 2023. The new name reflects a new focus on afforestation and reforestation activities, and those restrictions on activities in the forest as provided under the Forest Conservation Act 1980 specifies activities that will be excluded from restriction on the reservation. Thus, these activities include conservation, forest development, wildlife related works, and Government of India may exclude any survey, exploration, seismic survey from restrictions on reservations, as while the 2023 Act adds more objectives to the restrictions on reservation lists, such as zoos and safaris under the Wildlife Protection Act 1972, owned by the government or any authority in forest areas other than protected areas, also providing ecotourism facilities. silvicultural operation enhancing forest growth and any other purpose specified by the central government. So, the very act also relates to certain important key features such as the land under the purview of the act. So, the 2023 Act provides that two types of land will be under the purview of the Forest Conservation Act, such as land notified as a forest under the Indian Forest Act 1927 or under any other law, and land not covered in the first category but notified as a forest on or after 25th October 1980 in a government record. And also, we found certain criticisms relating to the very limited scope of the Forest Conservation Act as Supreme Court in the important leading case T.N.Godavarman versus Union of India held that the provisions of the Forest Conservation Act will apply beyond notified forest to all areas recorded as forest in any government record. The 2023 Act proposes that Forest Conservation Act will apply only to those lands which are recorded as forest on or after 25th October 1980, thus restricting the scope of the government judgment. This is significant exclusion because it will potentially exclude 28% of India's forest outside recorded forest areas from the purview of the Act. The land excluded from the purview of the Forest Conservation Act will be easily diverted for commercial use. And also those lands exempted from the purview of the Forest Conservation Act. As per the 2023 Act's provisions, this includes forest land along a rail line or a public road maintained by the government providing access to a habitation or to a rail and roadsides amenities up to 0.10 hectares as another important key features of the 2023 Forest Conservation Amendment Act, which also provides that forest land situated within 100 kilometers along the international borders proposed to be used for construction of strategic projects of national importance or security are also exempted. Also, forest land up to 10 hectares proposed to be used for construction of security related infrastructure. Also, forest land proposed for construction of defense and paramilitary projects or public utility projects as specified by the Government of India, not exceeding 5 hectares. Left-wing extremists affected areas in states like Chhattisgarh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha, etc. Also, land changed from forest use to non-forest use on or before 12th December 1996 by any authority or authorized by a state or union territory, and we criticize these changes as it endangers ecologically sensitive biogeographic regions and biodiversity hotspots. This exemption provision of the Act is problematic as forest in the Himalayan or Trans-Himalayan and northeastern regions, which are rich with endemic biodiversity, will be exempted, and cleaning of these forests without any assessment and mitigation plan will lead to biodiversity loss and increase the vulnerability of the ecological and geologically sensitive areas. So, incentivizing private agroforestry and tree planting or plantation activities. And now we would like to discuss the provisions in regard to that under the Forest Conservation Act 1980, which allowed private plantations or reforested land to be retrospectively earmarked as forest. This provision disincentivizes the private parties, while the 2023 Amendment Act provides incentivizes the private parties by allowing the diversion of private forest for commercial other users without the need for acquiring forest clearance. And it is ineffective afforestation for commercial lands. So the act allows the diversion of private forest for afforestation activities. This may not help create a permanent carbon stock, as they can simply be used as carbon credits. So, in that connection, what exactly carbon credits means, which are otherwise also called as carbon effects? They are permits that allow the owner to emit a certain amount of carbon dioxide or other greenhouse gases. They are awarded to organizations based on quantities of greenhouse gases that they kept out of the air or removed from it. The carbon credit owner can sell it to organizations that have exceeded their limit. And another important key feature relating to assignment leasing of forest land. So, as per the provisions of the Forest Conservation Act 1980, the state government or any authority requires prior approval of the Government of India for assigning forest land to any organization, private person, authority, or corporation not owned by the government. But the Amendment Act of 2023 provides that state government or any authority to do this assigning to any organization subject to terms and conditions prescribed by the Government of India, and the power to issue directions as per the 2023 Amendment Act, that the Government of India may issue directions for implementing the Forest Conservation Act to any other authority, organization under or recognized by the center, state or union territories. And as we found the very drawback in the Amendment Act, that it diluted the power of the Forest Conservation Act, as the very terms like proposed ecotourism facilities and any other purposes which are too vague and can be exploited or misused for commercial purposes. And now we would like to discuss about the biodiversity loss, and in particular the 2023 Amendment Act proposes to ease the land transfer for compensatory afforestation. It will not serve the ecological purpose until fundamental changes are made. Generally, monoculture is practiced in compensatory afforestation, which leads to biodiversity loss, and it is a kind of violation of the constitutional rights that we found the provisions of exemption without the consultation of local individuals violates the Forest Rights Act 2006, the Panchayat Act, and the constitutional provisions for the scheduled tribes. The requirement of consent for diverting forest lands give legal recognition to the rights of the forest dwellers which is recognized under the Forest Rights Act 2006. And now I would like to make a critical analysis on the very provisions and that is relating to constitutional provisions for conservation of forest. So, as per the provisions relating to fundamental rights, as falling under Article 21, right to life, no person shall be deprived of his life or personal liberty except according to procedure established by law. Thus, it guarantees the fundamental right to life, so right to a healthy environment free of the danger of diseases and infection, etc., is inherent right. So also right to healthy environment as part of Article 21 was first recognized in the important landmark judgment, and that is rural litigation and entitlement Kendra versus state of Uttar Pradesh, which is popularly known as the Dehradun quarrying case. And also he found the directive principle of state policy under Article 48A, which provides protection and improvement of environment and safeguarding of forest and wildlife, so the state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the countries. Also, we found regarding that constitutional provision relating to fundamental duties under Article 51A, Clause G, to protect and improve forest and wildlife and to have compassion for all living creatures as it is provided under the Constitution of India. So, these are the critical analysis that we have made in connection to the newly amended Forest Conservation Act. So, we would like to conclude the very discussion on Forest Conservation Act 1980 and the necessary amendments made in 2023, which in particularly after the critical analysis, even we found certain important provisions relating to ensuring balance between forest conservation and economic activities. The Act of 2023 add certain activities to this list such as the safaris and ecotourism facilities. These also include prospecting, investigation or exploration and seismic surveys. The activities may help in economic development in the case of prospecting for minerals which may lead to mining, may even contribute to national priorities such as energy security and industrial growth. However, there may be a need to balance economic benefits of such activities with that of conserving forest. It is not clear why the requirements of a case by case examination by the central government to determine such balance is being replaced by a blanket exemption, and the very purpose of zoo inside the forest is unclear under the Act. So the Act of 2023 as exempts zoos from requiring prior approval under the 1980 Forest Conservation Act. The purpose of allowing a zoo inside a forest is not clear. So, the apex court of Supreme Court in 2023 itself has remarked that the do not appreciate the necessity of having a zoo inside a tiger reserve or national park. This was in the context of the National Tiger Conservation Authority granting permission for allowing tiger safaris within tiger reserves and national parks. The idea of such tiger reserves and national parks is that such fauna resides in its natural habitat and not in artificial environment. In particularly as regarding the very question relating to the balance as already we have discussed, the central government has already created similar exemptions for certain projects through guidelines under the 1980 Act and also in the year 2009. 19. These projects include security related projects near borders, infrastructure projects to left wing extremism affected areas, and the exemptions are subject to certain conditions such as the forest area involved must not be within a national park and or a wildlife sanctuary. The user agency must have explored all feasible alternatives to minimize the use of forest land or land diverted for some usages, including border security, will continue to be deemed as forest land. So the Act does not include such conditions when granting exemptions. So, in that connection, another important provision that a significant portions of delays in forest clearance take place at the state level. The Ministry of Defense in 2019 stated that 51 border roads projects, non-Indo-China border roads, were pending due to forest clearance. Of these, 29 were pending with the state governments. So, on May 2023, of the 2,235 applications for all forest clearance pending for the first stage of approval, only 1,891 are pending with state government authorities and the remaining are with the central government. So, finally, we found under the new act, that is the Forest Conservation Amendment Act 2023, the mandatory it removes the mandatory central government approval for diversion of forest. In certain cases, this means that decisions regarding the diversion of forest land would be taken by state governments and the Union Territory Administration only, according to the statement of objects and reasons of the amended Act. There is a need to fast track strategic and security related projects. However, such projects get delayed due to various reasons. Further, giving a blanket exemption for all security related projects may not be appropriate given the very impact it may have on forest cover and biodiversity. So, almost we have discussed all important changes made under the Forest Conservation Amendment Act 2023 in comparison to the Forest Conservation Act 1980.